We just want to take you to the Pretoria Magistrates Court. One of the big stories we've been watching for you is around the arrest of these 12 police officers, including generals, who are implicated in the multi-million rand Medicare24 SAPS contract. That's, of course, linked to Vusimuzi Matlala's company. There they are in the dock. Proceedings are just about to begin, with Matlala also amongst them. Let's listen in.
Worship, the appearances for today are as follows. The date being the 25th of March 2026. Presiding officer is Mr. Miller. Public prosecutor is Advocate S. Manilal, assisted by Advocate Creel. Interpreter is Mr. Mopale and Ms. Mashaba. Worship, I understand that there are no interpreters required for today's proceedings. Court clerk is Mr. Fries. On record for accused number 1 is Mr. Maluleke. For accused number 2 is Mr. Maluleke. For accused number 3 is Mr. Fobe. For accused number 4 is Mr. Maluleke. For accused number 5 is Mr. Matikela. For accused number 6 is Advocate Matobe. For accused number 7 is Mr. Fobe. For accused number 10 is Advocate Lobsher. For 11 is Advocate Bischoff. For number 12 is Advocate Nechaba. For number 13 is Advocate Momalo. For accused number 14 is Advocate Lepondo. For accused number 15 is Mr. Haasbrook. For accused number 16 is Mr. Maluleka. Your Worship, all accused are in custody and the matter is for bail, the issue of bail to be dealt with. Your Worship, briefly, this matter relates to the awarding of a tender to a company called Medicare24 District. Accused number 1 and 2 are charged with fraud relating to this unlawful award of the tender, and the tender amount being 228 million. Accused number 3, 5, 6, 10, 11, 12, 13, 14, 15, and 16 are also charged with fraud in relation to the tender. These accused were members of the Bid Evaluation Committee, and the amount of the fraud for which they've been charged is 228 million. Accused number 7 is similarly charged with fraud. He was not a member of the BEC at the time, but was appointed as the quality assurer to ensure that all the compliance by the bidders were met. The amount of the fraud is 228 million. In relation to accused number 7. Accused number 4 is charged with corruption in that she is a member of the South African Police Force and was an end user for the services provided by accused number 1 and Medicare Tshwane District Municipality. Accused number 4 received 3 payments respectively in the amount of 100,000 per payment, totaling 300,000. Accused number 1 is also charged with corruption in that accused number 1 gave the gratification of the 300,000 to accused number 4 in 3 payments. Accused number 1 and 4 are also charged with money laundering relating to the same payment of 300,000, which was concealed and disguised and moved to various different entities until it reached the hands of accused number 4. And accused number 4 is charged in terms of section 6 of POCA, which relates to the acquisition, possession, and the uses of the proceeds of unlawful activity. And this also relates to the 300,000 rands that got into our possession. Your Worship, the state has a written confirmation in terms of section 6011A that has been signed by the investigating director, which indicates that the charges for which the accused have been charged for falls within the ambit of Schedule 5. May I have leave to handle this?
It will be Exhibit 8.
Thank you. Your Worship, the state is opposed to the bail in respect of accused number 1, as he is currently in custody on another matter. Your Worship, I have had discussions with my learned friend acting on behalf of accused number 1, and he indicated that he would not be applying for bail at this stage, and is also agreeable with the date that the state is going to suggest for the matter to be postponed. I will deal with the date later. But for all intents and purposes, for today's proceedings, accused number 1 will not be applying for bail. Your Worship, the state is not opposed to bail in respect of all of the other accused, and the state will, in that regard, place on record the bail affidavit of its investigating officer, which will deal with the issue of bail and the amounts, etc. Your Worship, I leave it now for the defense to commence with their
Thank you, sir. Mr. Matlala, case number 2.
Yes, Court, please, Your Worship. I actually appear for number 1, number 2, as well as accused number 4. Firstly, I will deal with the position with regard to accused number 1. I had discussions earlier on with my colleagues from the NPA with respect to the position of accused number 1. Firstly, being that he is currently detained at Kokstad and was only brought to Pretoria late yesterday. I received a call from the prison informing me that he was here, but it was extremely late, so I had not yet had an opportunity to consult him. I took instructions from him this morning. I communicated the position with the state, and there was some sort of an understanding that with respect to accused number 1, we request that the matter be adjourned to the 3rd of April. This is for purposes of consulting him as well as engaging the NPA on certain issues that we'll place on record on the 3rd. Yes, the 3rd of April.
This is not a public holiday.
Oh.
It is a public holiday.
Apologies, Your Worship. We work almost every day, so now we've lost track of these issues. Then we'll obviously move to suggest the 7th of April. This will enable my office sufficient time to consult the accused in custody, and I can confirm now that we have booked consultations with him for tomorrow as well as for Friday to advance the receipt of instructions, and will be in constant contact with the investigators as well as the NPA if needs be, in preparation for the 7th. And then with respect to...
Excuse me, but this 7, that won't be for formal bail application.
No.
It's just a date for consultation.
Yes. It's a date for consultation as well as for us to engage with the NPA on various issues. And I must say that the engagement is already commenced. And then with respect to accused number 2, Mr. Murray, I have prepared an affidavit in support of his application to be released on bail. I placed on record that earlier on the legal teams approached the court with a view that in the interest of time, the prepared affidavits be handed up to the court instead of being read out verbatim.
That is correct.
And in light of same, Your Worship, may I hand up the affidavit?
You can, sir. It will be Exhibit B. Mr. Murray, stand up, sir. Do you confirm your affidavit which been handed to me by your lawyer? You may be seated again.
Your Worship, that will be accused number 2's application. Then I move to the application of accused number 4, Ms. Macheng. The position is the same as accused number 2. An affidavit has been prepared on the instructions in support of a release on bail. With permission of court, may I hand same up as an exhibit?
Will be exhibit C, right? Yes, so Mrs. Majane, do you confirm your bail affidavit now here, exhibit C?
Yes, I do.
And you did?
Your Worship, that will be the application of accused number 4 in support of a release on bail. We'll obviously deal with the issue of quantum at a later stage once the state is escort, please. Your Worship.
Mr. Forward.
Your Worship, as the court pleases, Your Worship, confirm that I appear on behalf of accused number 3, Mr. Rand Cartwright, in these proceedings, and also accused number 7, Mr. Tabiso Malika. I see my learned colleague proceeded with the application for accused number 4, Your Worship, as well. So I'm going to deal with both my accused, if that is in order with the court, Your Worship.
Accused 3 and 7.
3 and 7, yes, Your Worship. Your Worship, likewise, we have prepared an affidavit for the accused, accused number 3. The content of the affidavit has been discussed with the accused. We've taken instructions, we've drafted the affidavit, he's perused the affidavit, he signed, he confirmed the content of the affidavit, and he further confirmed, Your Worship, the provisions of Section 6011 of the Criminal Procedure Act, including that evidence tendered during these proceedings might be used against him in the subsequent trial, save for previous convictions and pending cases, and also the penal sanction should he fail to disclose certain information in terms of the Act. Accused understands same, Your Worship. We beg leave to hand up the affidavit of accused number 3 in these proceedings as exhibit.
Will be exhibit D.
Exhibit D, Your Worship.
Mr. Cartwright, do you confirm your bail affidavit? You may be seated.
Thank you, Your Worship. I proceed with accused number 7, Mr. Malika. Same applies, Your Worship. The provisions of the Criminal Procedure Act, Section 6011, has been explained to the accused. Also, the implications of the non-disclosure clause, etc. Your Worship, what I just wish to bring to the Honourable Court's attention, and my learned colleagues will address Your Worship also on that in the affidavit of the investigating officer, that unlike accused number 3, accused number 7 has got a pending matter for which he's out on bail. Also relates to similar charges that the one is before Your Worship. Save for that, he does not have any previous convictions and there's no further pending matters against him. The investigating team is also the same team that's busy investigating the first matter, Your Worship. However, we submit with respect, Your Worship, it's not a question of the accused was out on bail when he committed this offence, Your Worship. I beg then leave to hand up the affidavit of accused number 7 as exhibit E in these proceedings, Your Worship.
Exhibit E.
That will be then the application for accused number 7.
Tanishu Maleka, do you confirm your bail affidavit? Yes, sir. You may be seated. Mr. Kitela, for case number 5.
As it pleases the court, Your Worship, I confirm appearance on behalf of accused number 5. I confirm the charges he's facing, Your Worship, and I've been instructed to apply bail on his behalf. Your Worship, as it has already been, indicated, we will be proceeding in terms of an affidavit. I just want to confirm that I've consulted with our client. We have made him aware of the provisions of Section 611B. He has confirmed that he has got no pending cases, he has got no outstanding warrants, and equally so, he has got no previous convictions. So he understands the consequences thereof of non-disclosure and all that they have all been discussed. And in that respect, Your Worship, we would love to, hand over. As it please the court, Your Worship, that is our case.
Do you confirm your bail statement? Advocate Matlala.
As the court pleases, Your Worship, it's my Mataboche. I noted that my learned colleague for the prosecution misspelled it. I confirm appearance on behalf of accused number 6, duly instructed by the Office of Silica Attorneys. We are instructed to proceed with the bail application in respect of Mr. Imeleni Patrick Natemo, who is accused number 6 in court. Similarly, I have consulted with him together with my attorney and have indicated to him the importance of the provisions of Section 6011B of the Criminal Procedure Act. He has disclosed that he does not have any pending case, that he do have a previous conviction of reckless and negligent driving, which was more than 10 years ago and which has been expunged. He does have a certificate in this regard. He also indicates that he was at some point charged with culpable homicide, which to his understanding he was not convicted of. In support of his application, we've prepared an affidavit, which we request that it be accepted as an exhibit in support of his bail application. I beg leave to hand same to this honorable court. Your Worship.
Will be exhibit G.
As the court pleases, I will then give my other colleagues 10 and only come back in dealing with amounts. Thank you.
Mr. Mutengwe, do you confirm your bail statement? I confirm. Thank you. Advocate Lauscher for case number 10.
Please the court, Your Worship. I confirm my appearance on behalf of accused number 10. And similarly, we've prepared the bail affidavit, which I beg leave to hand up. As it pleases. Your Worship, in summary, my client has employment. She's been living in a residence for 28 years. There's no reason for suspicion that she'll contravene any of the considerations set out in Section 64A to E. She has 7 dependents, and at this stage she intends to plead not guilty. There has been agreement in respect of the amount as discussed with the state, as well as the bail conditions being submission of her passport, that she will not interfere with witnesses, and that she will attend all proceedings. As it pleases, that is the case for the 10th accused, Your Worship. As it pleases.
Mr. Stemba, do you confirm your bail statement? Exhibit H. Thank you. Advocate Bischoff, case number 11.
May it please the court, Your Worship, I confirm my appearance on behalf of the accused number 11. My instructions are from Ines Bredenkamp attorneys. The accused number 11 has similarly deposed to an affidavit this morning, Your Worship. In short, the essentials, she has no pending cases, no prior convictions. She has extremely close familial ties and emotional and family ties, Your Worship. no assets or family abroad, distant family abroad. She doesn't know where they are. She poses no risk for flight and will stand trial, Your Worship. And the same goes for the committing of further offences or influencing witnesses. We don't even know what the case against her is. So there's no risk in that regard. I submit, Your Worship. I beg leave to hand up the affidavit.
Exhibit J.
Sorry, you.
Exhibit J.
May it please you.
Ms. Jonker, do you confirm the statement, ma'am? Advocate Michelva, case number 12.
Good afternoon, Your Worship. Your Worship, I do confirm my appearance on behalf of accused number 12. Your Worship, without wasting the court's time, because the reason why we agreed in this procedure to save time is that except that this arrest has really induced some shock and trauma towards my client, Your Worship, the accused number 12 in this regard, I wish to proceed similarly with my other colleagues, that an affidavit has been prepared and my client has been warned about the legal consequences that fall through for non-disclosure, for criminal record, and any other warrant that could be standing against, and she has understood. It may be, if there's no objection, it may be administered an exhibit.
The exhibit K. Mrs. Lenono, do you confirm your bail affidavit? You may be seated.
That's the application, Your Worship.
Advocate Numalo.
Thank you, Your Worship. I confirm my appearance on behalf of accused number 13. I'm duly briefed by Siamane attorneys. Your Worship, similarly, we have prepared an affidavit in support of bail application. We'll ask court's indulgence to hand it as an exhibit in support of bail application. Your Worship, we confirm that we consulted with our client and we made her aware of the consequences regarding the non-disclosure of any pending or previous convictions. However, we have find that she's still a baby. This is the first time for her to rub shoulders with the law. She doesn't have any pending or a previous conviction. Your Worship, we have seen the bail conditions suggested by our colleagues. There's only one thing that would want to address the court when the court gives us an opportunity again. It's only with regard to the quantum because of her affordability.
Yes, we will deal with the quantum a little bit later.
As the court please. That's the applications by the accused number 13.
Thank you, sir.
As court please.
Advocate Ripondo.
Your Worship, maybe if I can get the number
L.
L. Thank you, Your Worship.
As it pleases the court, Your Worship, I confirm my appearance on behalf of accused number 14, Nonjabulo Nomfundo Brightness Ngadi. I've been instructed by Matseto attorneys, Your Worship. Same with my client, the rest of the other accused. She has prepared an affidavit which has been commissioned on to today, the 26th of March here at Pretoria. Your Worship, we concede that this is a Schedule 5 offense in that the amounts involved, the charge involves amounts of more than 500,000. or as the charge sheet alleges, was done in acting in the execution of furtherance of a common purpose, and or that she is a law enforcement officer. In response to the provisions of Section 60, subsection 11, she has no previous conviction, she has no pending case, she is not out on parole, and she confirms further that she's been informed of the consequences of giving false information. Your Worship, in her affidavit, she has fully addressed the court on the factors as enumerated in Section 60, subsection 4A to E, read with the corresponding sections or subsections 5, 6, 7, 8, 8A, and 6, 60.9, and prays in the end that she has discharged her honors of proving to this court that the interest of justice does dictate that she be released on bail, Your Worship. I beg leave to hand in her affidavit as forming part of the court record.
Will the Exhibit M?
Just one thing, Your Worship. Thank you, Exhibit M. One thing from the charge sheet, she is indicated as a male person, Your Worship. She was born a female, and she remains a female, married with 2 children, Your Worship. May it just be corrected as such. Thank you.
It has been corrected. Mrs. Ngadi, do you confirm your bail statement? You may be seated. Mr. Asbury, for accused number 15.
Yes. Afternoon, Your Worship. I also confirm my appearance on behalf of accused 15 in this matter, Your Worship. I confirm that the terms of Section 60(11)(b) was well explained to the accused in this matter, Your Worship. I also confirm that he has no previous convictions or pending matters or on parole. And I want to place on record that he is not in possession of a valid passport. His passport has lapsed. And then, Your Worship, we also prepared an affidavit we want to end up in that complied with the rules in that regard, Your Worship, as it pleases.
Will the Exhibit N? Thank you, sir.
Thank you.
Mr. Paulson, do you confirm your bail statement, sir? Yes, I do, Your Honor. May be seated. Mr. Maluleke, again. You're for the case number 16, is that correct?
Correct, Your Worship. Good morning, Your Worship. I confirm my appearance on behalf of accused number 16, Mr. Netsengaye Johannes Munyai. Your Worship, I confirm that we have consulted with the accused and we have prepared the bail affidavit, Your Worship, in support of his release on bail, Your Worship. We also, Your Worship, made it clear to him with regard to the consequences regarding Section 60(11)(b), Your Worship. He confirmed that he does not have any previous conviction or pending cases or outstanding warrants, Your Worship. With your permission, Your Worship, may I submit the bail affidavit prepared?
Will the Exhibit O?
As pleases the court.
Mr. Munyai, do you confirm your bail statement? Thank you, sir.
As the court pleases.
Is that the case for the applicants? Any further evidence? Nothing. Yes, sir.
Thank you, Worship. Worship, before I get into the state's case, just to address accused number 14 is the error made in terms of the citation. No offense meant, Your Worship, we will correct that in the charge sheet. Worship, just to also place on record, the charge sheet, the copy of the charge sheet has been handed to all the legal representatives of the various accused. And that was handed this morning before the proceedings. Your Worship, the state would like to be placed in possession of all the bail affidavits that have been submitted to the court. We have not been given a copy thereof.
Yes, I will give it. I just want to
As the court pleases.
keep it here with me for a little while.
Your Worship, just one other issue to clarify before we move into the state's case. Your Worship will notice on the charge sheet the J15. The accused are numbered sequentially. However, accused number 8 and 9 are not reflected on the charge sheet.
Yes.
Your Worship, accused number 8 and 9 are actually corporate accused. That is Medicare24 Tshwane District Pty Ltd. And accused number 9, Luxo Africa Pty Ltd. Your Worship, this morning the state is in the process of serving summons on accused number 1, who is a director of both these entities, and we will be adding those corporate accused on the next occasion when we appear in court. However, Your Worship, just for practical purposes, we did not change the charge sheet in terms of the numbering, as we numbered them sequentially from 1 to 16, and any changes in the numbers would have resulted in us revamping the entire charge sheet. So I just wanted to bring that to the court's attention.
Understand, sir.
Thank you, Worship. Worship, the state is in possession of the affidavit of the senior criminal investigator in this matter. The affidavit deposed by one Sunil Belochan. Worship, may I have leave to read his affidavit into the
You can
record?
proceed, sir.
Worship, may I have leave to read?
Thank you, sir.
The affidavit reads, affidavit in support of bail application. I, the undersigned Sunil Belochan, do hereby make oath and state the following. I am employed by the National Prosecuting Authority of South Africa as a senior criminal investigator in the Investigating Directorate Against Corruption, known as IDAC. The facts deposed to herein are derived both from the affidavits obtained, documentation at my disposal, and from my personal knowledge, unless I state to the contrary or the context indicates otherwise. They are to the best of my knowledge and belief both true and correct. The investigating director, as head of IDAC, authorized an investigation into this matter. I am part of the team of officials attached to IDAC, who is designated in terms of Section 28(2) of the National Prosecuting Authority Act 32 of 1998 to investigate the matter as described in paragraph 7 and Part A, Part B, Part C, and Part D below. I am the lead investigating officer in Silverton CAS 285/03/2026. I make the statement in terms of Section 60 of the Criminal Procedure Act 51 of 1977. I submit that the bail application for all accused resort under Schedule 5 of the Criminal Procedure Act. The investigating director of IDAC has submitted a certificate in terms of Section 60(11) capital A subsection A of the Criminal Procedure Act, confirming that the offences for which the accused have been charged falls within the ambit of Schedule 5 offences as stipulated in the CPA. The matter relates to the awarding of a tender issued by the South African Police Services with reference bid number bid 19/1/9/1/94 TP in brackets 23. The tender was ultimately awarded to Medicare24 Tshwane District Pty Ltd on the 14th of June 2024. The monetary award of the contract amounted to 228,665,280 rands. The accused involved in this matter are as follows: Vusimuzi Matlala, hereinafter referred to accused number 1; James George Murray, hereinafter referred to accused number 2; Brian Neville Cartwright, hereinafter referred to accused number 3; Rachel Macheng, hereinafter referred to accused number 4; Alpheus Teminkosi Ngema, hereinafter referred to accused number 5, Nimaleni Patrick Ntengwe, referred to as accused 6, Tomisho Maleka, referred to as accused number 7, Vusimuzi Precious Temba, referred to as accused number 10, Christy Yonker, referred to as accused 11, Petunia Lenono, referred to as accused number 12, Onika Teloalele, referred to as accused 13, Nonjabulo Ngadi, referred to as accused 14, Anton Paulson, referred to as accused 15, Natsengai Moniai, referred to as accused 16. I am duly authorized to depose to this affidavit, which is made to oppose the bail application for accused number 1 and in relation to accused 2, 3, 4, 5, 6, 7, 10, 11, 12, 13, 14, 15, and 16. I do not oppose their bail applications, subject to the discretion of the court and the proposed conditions set out in paragraphs 42 to 44 herein. My affidavit sets out the allegations, the accused's involvement, and the offences perpetrated in 4 parts, as set out below. Part A deals with the submission of the tender with the bid number, bid 19/1/9/1/94 TP 23. Part B, facilitation and approval of the tender with the same bid number. Part C, gratifications offered and accepted, corruption. Part D, money laundering. Part A, the submission of the tender with the bid number reflected above, and it relates to the fraud perpetrated by accused 1, 2, and Medicare24 Tshwane District. Paragraph 11. On the 31st of January 2024, the Division Supply Chain Management of the South African Police Services advertised a tender referenced 19/1/9/194 TP 23. The closing date of the tender was 19th of February 2024. Medicare24 Tshwane District, through the instrumentality of accused number 1, submitted a bid in response to the advertisement for the tender as referred to above. James George Murray and Brian Neville Cartwright, accused 3, assisted Medicare Tshwane District and accused number 1 at various stages of the preparations of the bid submitted by Medicare24 Tshwane District through the instrumentality of accused number 1. In paragraph 3.5 of one of the standard bid documents, termed SBD forms, SBD 4, Medicare24 Tshwane District, through the instrumentality of accused number 1, declared that, quotations, there has been no consultations, communications, agreements, or any arrangements made by the bidder with any official of the procuring institution in relation to this procurement process prior to and during the bidding process, except to provide clarification on the bid submitted where so required by the institution. And the bidder was not involved in the drafting of the specification in terms of the reference of this bid. Close quotations. Paragraph 15. The declaration by Medicare24 Tshwane District through the instrumentality of accused 1 and 2 were false in that accused number 1 had consultations, communications, agreements, and arrangements with accused number 3 prior to and during the bidding process in respect of the tender as referenced above. Accused number 1, 2, 3, and Medicare24 Tshwane District failed to disclose the material facts that they had consulted about the bid submitted by Medicare24 Tshwane District through the instrumentality of accused number 1. On 13 February 2024, accused number 1 completed and signed bid documents on behalf of Medicare24 Tshwane District in his capacity as the sole director and the shareholder of Medicare24 Tshwane District. The said bid documents were then submitted to the Supply Chain Management. Amongst the several misrepresentations made relating to the capacity of Medicare24 Tshwane District to perform in terms of the advertised tender were the following. 1. Misrepresented in the SBD1 form that his business address was 103 North Rand Road, Bardeen, Boksburg, Gauteng 1459. 2. Misrepresented his business addresses in 8 provinces by providing false addresses. 3. Misrepresented that it had a computerized system that was compatible with the SABC system of SAPS. 4. Misrepresented that it had the required medical infrastructure in the 9 provinces of the Republic of South Africa. 5, misrepresented that it had personnel as required in the bid specifications. The tender was awarded to Medicare 24 Tshwane District based on the misrepresentations, which caused actual prejudice in the amount of 50,310,590 rands, 0.68 cents, to the South African Police, the National Treasury, and the public at large. Part B, facilitation and approval of the tender. This is the fraud perpetrated by the BEC members accused 3, 5, 6, 7, 10, 11, 12, 13, 14, 15, and 16. Paragraph 19. Brian Neville Cartwright, accused 3, who was the subsection commander of tactical equipment of the division, supply chain management of the SAPS, was appointed to serve as the facilitator of the bid evaluation committee that evaluated the bids advertised. Paragraph 20, at the time when accused 3 was appointed as a facilitator of the BEC, accused number 3 was well acquainted and knew accused number 1 and Medicare 24 Tshwane District and should have declined the appointment as facilitator due to the conflict of interest. 21. Accused 3 in addition was involved in the compiling the daily minutes of the BEC and the BEC submissions to the bid adjudication committee. 22. The other members appointed to BEC including accused 3 were 1. Alpheus Ngema, a brigadier in the South African Police Force. 2. Nemeleni Ntengwe, a brigadier in the South African Police Force. 3. Vusimuzi Temba, a major general in the SAPS. 4. Christy Bionka, a brigadier in SAPS. 5. Petunia Lenono, a brigadier in SAPS. Onika Teloale, a brigadier in SAPS. Nonjabulo Ngadi, a colonel in the SAPS. Anton Paulson, a colonel in the SAPS. And 9. Natsengai Monyai, a colonel in the SAPS. These members of the BEC evaluated the bids submitted by the bidders, who responded to the invitation for the bids in respect of the tender referenced above. Paragraph 24. On the 2nd of April 2024, the members of the BEC conducted a due diligence on supposed to be Medicare Tshwane District. Reference to suspect, Your Worship, is from the fact that we had not changed the corporate or charged the corporate accuser. The due diligence was conducted at the premises of Medicare 24 Holdings in Boksburg, which was not the premises of Medicare 24 Tshwane District, being the 103 North Rand Road, Badi in Boksburg, Gauteng address, as listed in the bid documents SBD1 form. Accused 2 was present and attended the due diligence at Medicare 24 Holdings premises. 25. A due diligence report dated 12th of April 2024 was compiled by all the members of the BEC who conducted the due diligence. Several misrepresentations were made by the members of the BEC who conducted the due diligence on Medicare 24 Tshwane District as follows. 1. Misrepresented that Medicare 24 Tshwane District's business address was situated at 103 North Rand Road, Bardeen, Boksburg, Gauteng, 1458. 2. Misrepresented that Medicare 24 Tshwane District had business addresses in the 8 provinces. 3. Misrepresented that Medicare 24 Tshwane District had a computerized system that was compatible with the PASAP system. 4. Misrepresented that Medicare 24 Tshwane District had infrastructure in the 9 provinces of the Republic of South Africa. 5. Misrepresented that Medicare 24 Tshwane District had personnel as required in the bid specifications. 6. Misrepresented that Medicare 24 Tshwane District had mobile units in all 9 provinces and complied with the specifications of the tender reference above. Paragraph 26. Based on the misrepresentations by the BEC, Medicare 24 Tshwane District should have been disqualified. 27. Accused number 7 was a senior procurement officer responsible for conducting thorough screening of the BEC submission and attachments thereto to ensure its truthfulness, accuracy, and correctness before signing off and recommending that the BEC bundle containing its recommendations should proceed to be placed before the BAC. 28. Accused 7 had a duty to ensure that BEC bundle was sent back to the BEC, and accused 7 should have raised several queries which have resulted in Medicare 24 Tshwane District being disqualified, and the BEC bundle was not placed before the BAC. 29. On 14 June 2024, the BAC considered the resubmission dated 22nd of May 2024 and took a decision to appoint Medicare Tshwane to provide the said services at a total amount of 228,665,280 rands. 30. After the award of the contract, SAPS paid in an amount of 50,310,590 rands .68 to Medicare Tshwane, resulting in actual prejudice suffered by SAPS. Part C. Gratifications offered and accepted. This relates to count 3 and 8. Corruption perpetrated by accused number 1, 4, 8, and 9. Paragraph 31. Vusimuzi Matlala, accused 1, was the director of Medicare Tshwane District and Luxo Africa Brand Investments. Medicare 24 Tshwane District received the total amount of 50,310,590.68 in relation to the contract induced by fraud. 32. Rachel Macheng, accused number 4, was a member of SAPS and was stationed in the Division Forensic Science Services. The Division Forensic Services was one of the end users of the services that were rendered by accused number 1 and or Medicare 24 Tshwane District in terms of the contract awarded to accused number 1 and or Medicare Tshwane District. Paragraph 33. In terms of her roles and responsibilities in the SAPS, she referred multiple members from SAPS for medical screening to Medicare 24 Tshwane District that resulted in purchase orders being issued in relation to the services that Medicare 24 Tshwane District was contracted to provide, and thereby enabled Medicare 24 Tshwane District to invoice the SAPS. 34. Accused number 4 accepted or agreed or offered to accept gratifications in the form of payments from accused number 1 and Medicare 24 Tshwane District in 3 payments totaling 300,000 during the period 13 January 2025 to 17 of March 2025. 35. Accused number 1, Medicare 24 Tshwane District and Luxo Africa Brand Investments gave or agreed or offered to give gratifications in the form of payments to accused 4 in 3 payments totaling 300,000 during the period 13 January 2025 to 17 March 2025. Part D. Money laundering. Counts 9 to 11. Money laundering by accused 1, 4, 8, and 9. Paragraph 36. The movement of funds emanating from the contract induced by fraud resulted in the disguise or concealment of the nature, source, origin, movement, location, or disposition of the said funds. 37. Medicare 24 Tshwane District received the amount of 50,310,590.68 in 199 payments in its F&B account. This account was under the control of Vusimuzi Matlala, accused number 1. 38. The 300,000 rand described in paragraph 34 and 35, which was paid and received as unlawful gratifications, was subsequently laundered through various accounts and was ultimately received by accused number 4 in contravention of section 4 and 6 of POCA, and this is the money laundering offences. Regarding the arrest of the accused, paragraph 39. On the 24th of March 2026, IDAC investigators, including myself, executed an operation which resulted in accused 1, 2, 3, 4, 5, 6, 7, 10, 11, 12, 13, 14, 15, and 16 being arrested on authorized warrants of arrest, processed at the Silverton Police Station, and detained accordingly until their appearance before this honorable court. 40. All accused residential addresses have been verified and is confirmed that the addresses are correct. 41. I profile each of the accused and state as follows. Accused number 1. I confirm that he has a pending case of conspiracy to commit murder. The accused was denied bail on that matter. Accused 2, I confirm that there are no previous convictions or pending warrants. Accused 3, I confirm that there are no previous convictions or pending warrants. Accused 4, I confirm that there are no previous convictions or pending warrants. Accused 5, I confirm that there are no previous convictions or pending warrants. Accused 6, I confirm that accused 6 has a previous conviction of culpable homicide in 2018. Naboom Spade CAS 174/09/2016. Accused 7, I confirm that accused 7 has a pending matter of procurement fraud, Silverton CAS 360/10/2022. The accused is released on bail. Accused 10, I confirm that there are no previous convictions or pending warrants. 11, I confirm that there are no previous convictions or pending warrants. Accused 12, I confirm that there are no previous convictions or pending warrants. Accused 13, I confirm that there are no previous convictions or pending warrants. 14, I confirm that there are no previous convictions or pending warrants. 15, I confirm that there are no previous convictions or pending warrants. 16, I confirm that there are no previous convictions or pending warrants. Paragraph 42, I agree to bail being granted to accused number 2 to 16, subject to the following strict conditions and the court's discretion. Paragraph 42.1, that the accused attend each court appearance. 42.2, that the accused do not intimidate or influence any witnesses directly or indirectly. 42.3, that the accused hand over their passports to the investigating officer on the release of bail. And 42.4, that they do not leave the Republic of South Africa without an application to this court. With regard to the bail amounts, the following is submitted to the court. An amount of 80,000 be set for accused number 2, 3, 4, and 7. 43.2, an amount of 40,000 be set for accused 5, 6, 10, 11, 12, 14, 15, and 16. Paragraph 44, I submit that the amount of bail suggested will address the following to safeguard their attendance and ensure that they do not interfere and intimidate witnesses, such as to bullet 1, endanger the safety of the public or any particular person. Bullet 2, attempt to evade his or her trial. Bullet 4, attempt to influence or intimidate witnesses or conceal or destroy evidence. And last bullet, undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. Paragraph 45, I respectfully submit that the instance of justice permit the release of the accused on bail. Regarding accused 1 was requisitioned from custody and is currently appearing in another matter, a conspiracy to murder, in which he was not released on bail. 47, I respectfully submit that if accused number 1 wishes to apply for bail, I will depose to an affidavit to oppose the release of bail. 48, I respectfully submit that the instance of justice does not permit the release of accused 1 on bail. Signed at Pretoria on this 25th day of March 2026. The affidavit was signed and commissioned, signed by Sunil Belachan and commissioned on the 25th of March 2026 by the Commissioner of Oaths, name and surname Brian Kadiachi, who is also a senior investigator. Your Worship, may this affidavit be marked as Exhibit P. Your Worship, the State will present no further evidence and closes this case.
We will deal with the quantum later on, is that correct?
Your Worship, we at that point where I've suggested quantum, the defense may address you on quantum and then I will address the court on quantum thereafter.
Well, I just want to make a do anyone want to address the court before we start with the quantum?
Court pleases your worship. It's Matlala on behalf of accused number 6. It's important that we correct something at this stage of the proceedings. When I addressed the Honorable Court earlier, in our address in main for the application for bail, I indicated, and coming from the affidavit of accused number 6, that he has a previous conviction of reckless and negligent driving. He believes that he was charged with culpable homicide as well at a later stage, but he believes that he was never convicted for this charge and he was never sentenced. Now, from the affidavit of the investigating officer, it appears that the only previous conviction that they are able to pick up is that of culpable homicide and not the one of reckless and negligent driving. But nevertheless, we are stating this in order to make the Honorable Court aware that clearly there's confusion in as far as the previous conviction of culpable homicide. With regards to the one of reckless and negligent driving, he volunteered it and indicated that it was expunged. It's more than 10 years ago it was expunged, and that he does have a certificate in this instance, in this regard. Now, following what the state has already indicated, there would then need to be, there would then need to be an investigation as to what could have happened, because in his understanding, he was never convicted nor sentenced for the charge of culpable homicide, but he was convicted for the one of reckless and negligent driving. So we're placing this on record such that it does not come at a later stage and we're accused of having misled the court. It's important that we do this at this stage because we know that the provisions of Section 60, subsection 11B have dire consequences if one were to mislead the Honorable Court. I submit that there's no reason, or there was no reason for him to mislead the court in this instance, because the agreement right from the beginning in the morning was that the state is not opposing any bail. We do not want at this stage, Your Worship, to tamper with the affidavits. I would just request the state to investigate such that he's also clear about what is what in respect of this aspect, so that going forward he's clear about the reality and the actual situation around these convictions. At a later stage, if it does appear that perhaps he is mistaken, we'll deal with that and address that formally in another affidavit, because the affidavit is already evidence before court. Thank you, Your Worship.
Advocate Manila, any address with regards to that?
Your Worship, I do have the record from you, so we put that information forward based on the record. However, Your Worship, I do not wish to make any issue of taking issue.
No issue on the bail?
No, not at all.
I'm happy then.
Any other address, any other legal?
Thank you, Your Worship.
Sensitive? Nothing. Now, after the court is, judgment in short, after the court has listened to the evidence here and the statements by the accused here, the court finds then that the reasons which were put forward to this court is sufficient, that it is in the interest of justice that accused number 2 to 16 can be released on bail, except accused number 8 or 9, which is not represented at this stage or before this court. Therefore, we can start with the quantum with regards to the accused.
As the court please.
As court please, Your Worship, I will deal with the aspect of the quantum with respect to accused number 2. Your Worship, without repeating what appears on the affidavit of accused number 2, it's common cause that accused number 2 has been aware of this matter for some time. He has visited the office of the NPA. The records will confirm same. He has had meetings in the past with the investigating officers on this matter, and therefore it is quite clear that with that knowledge he still remained and he was arrested and he appeared in court for this matter. On that basis alone, one will obviously have to consider the case of State versus Atchison, which clearly states that bail should not be treated as some sort of a form of anticipatory punishment. And we say this for the following reason. The proposed amount of 80,000 itself will suggest some sort of punishment and defeats the purpose. The ultimate purpose of bail monies is merely to secure the attendance of an accused person in court on the next court appearance. That's the only purpose. Now, notwithstanding the seriousness of this matter, if we look at the totality of facts and the conduct of accused number 2 after he became aware of this matter, the fact that he previously even contacted the NPA to verify if there was a warrant of his arrest, and these issues are dealt with properly in his affidavit, and I'm avoiding to repeat it verbatim. He still remained. In any event, he's here today. It was so easy for the state to find him. When the IO contacted him during his arrest, he even provided them with his location and waited at that particular place until they reached him. And for that reason, Your Worship, we suggest that 80,000 is quite high. The amount that the accused can afford at this moment in time is 10,000 rand. He will attend to this case. He will be present, so he says, on the next appearance, as he has demonstrated for a period of over 6 months. After becoming aware of this matter, he remained. In fact, it's actually 9 months. He remained. He cooperated at all material times when he was required. He availed himself. And that is all that we can say with regard to accused number 2. And then with regard to accused number 4, Ms. Macheng is an employee of the SAPS. The SAPS knows where she resides. It is common cause that she's in suspension currently, and it's within reach to the SAPS at any point in time as and when they require her attendance, anywhere that they may so require, including the potential hearing that obviously will be scheduled to deal with the suspension issues. And for that reason, Your Worship, for someone who has been with the state for over 30 years, employed as a member of the SAPS, it will really be a travesty of justice if a bail will be granted in the amount of 80,000. And I say this because she has also been aware of these issues, has appeared in other forums to deal with the same issues, and she still remained. The state found her in a house. There was no resistance whatsoever. There's nothing that this 80,000 that is being suggested will achieve. The moment that they arrived at the house, she fully cooperated with the police. She did not resist arrest. And we submit that an amount of 10,000 will be sufficient. In any event, the state knows what they pay her. They know her salary. She's not one of strong financial means. And definitely 80,000 is not something that she will be able to afford. And it will speak to the issues that were raised in State versus Atchison, which then will result in some sort of an anticipatory punishment for somebody who intends to plead not guilty on all these charges. And on that basis alone, we submit that the court shows leniency and grants bail in the amount of 10,000 as proposed. This should be for both accused number 2 as well as accused number 4, Your Worship. Escort, please.
Mr. Forbury.
Bishop, likewise, I hold instructions on behalf of both accused number 3 and number 7 to address the issue of quantum with the court, Your Worship. Bishop, before we proceed to address Your Worship fully on the issue of quantum, we just want to place on record that both accused 3 and 7 reserve their rights to, at a later stage and probably during trial, deal with the allegations as set out in the affidavit for the state. So we're not going to at this stage respond to those allegations. Safe to say that both accused denies the allegations in total. And both the accused will plead not guilty. Bishop, the personal circumstances of both the accused has been set out in the respective affidavits, which to a large extent remains unchallenged. It's actual common cause that both accused 3 and accused number 7 are gainfully employed by the South African Police Services and situated at the SCM division. Accused number 3, Worship, holds the rank of a captain. It's my instructions, Worship, that his financial means are considerably less than that of the rank of a brigadier or colonel. And it's my instructions at this stage, Your Worship, that he earns a net salary of about 22,000 Rand per month. The address has been confirmed, Your Worship. We are mindful of the fact that the charges leveled against the accused are serious. However, Your Worship, that is in no way an incentive for the accused not to stand his trial. The state's attitude, in as far as both the accused are concerned, it's quite evident that they do not deem them as flight risks. And that is one of the most important factors that the court should look at this stage when considering what an appropriate quantum would be in the circumstances, not shying away from the seriousness of the charges leveled against them. Now, Your Worship, this matter with respect has been in the public domain for quite a considerable amount of time. Both the accused, and more specifically accused number 3, has learned about this investigation quite some time ago, even in fact last year. Accused number 7 likewise was contacted last year in October by the investigating officer concerning this matter. Accused number 3 was at a point also informed by the employer of investigations concerning this matter. At no stage, Your Worship, with respect, did any of the accused either not attend or not honor any commitments in this regard. They complied with all the investigations and all directives issued by the employer, and they played open card, Your Worship. Your Worship, with respect, accused number 7, although he holds the rank of a colonel, he earns a salary of about 72,000 gross after deductions, more or less 50,000 Rand a month. He's also a family man. His address has been known. On the previous matter, Your Worship, with respect, similar to this, it's also been investigated by the same team, also by the IDAC, and on that matter, the accused was called. He handed himself over and reported to Silverton Police Station, was charged, brought before this court, and was released on bail in the amount of 20,000 Rand. He has complied with all bail conditions. Has been religiously attending court.
That is accused number?
Accused number 7.
7.
Your Worship, it is my instructions from both the accused. Accused number 3 can afford an amount of 10,000 Rand, which we submit would be reasonable in the circumstances, taking into account the totality of the factors placed before Your Worship. And accused number 7 indicated that he can afford an amount of 20,000 Rand in lieu of bail, Your Worship. Your Worship, unless there's anything specific the court would want me to address, Your Worship, on that would be the submissions on behalf of 3 and 7.
Case number 5, Mr. Kitela.
As it please the court, Your Worship. Your Worship, we, on behalf of accused number 5, our argument is that perhaps we should just highlight the personal circumstances of the accused in this matter, Your Worship. The accused is a married man, is a pensioner. He has recently retired from the service since some time last year. He has got 2 children, 2 daughters, one at university, and the other one is at a matric level at the high school. Both of whom is, fully, supporting. And now, Your Worship, we do not intend to make light of the charges that the accused is facing. We appreciate the seriousness thereof, and but we just want to highlight, Your Worship, that he is being charged with corruption. He's also being charged with fraud. But having listened to the state making its case, Your Worship, there are not necessarily any allegations in respect of him as to how he has been gratified insofar as those charges are concerned. There is no allegation of gratification that he has received, or any gratification that he has requested in that respect. So, Your Worship, we are not making light of the charges, but we submit, Your Worship, that if you take into consideration the personal circumstances, is not necessarily able to afford a bail in the amount of 40,000 rand. So we propose that perhaps 10,000 rand would be a fair amount. He's able to, I've consulted with the family, I've consulted with him. They are in a position to post a bail of 10,000 rand. That would be affordable. Your Worship, I do not wish to belabor the argument or the point that the objective of bail really indeed is just to secure the attendance of the accused person at trial. He is eager to stand trial. He is very eager to clear his name. He is maintaining that he is innocent of the charges that is that are being leveled against him. So in that context, Your Worship, we submit that he should be afforded a bail amount of 10,000 rand, because there is really no point in him being given granted a bail of 40,000 rand that he ultimately is not going to be able to to afford. As it pleases the court, Your Worship, that is our submission insofar as the quantum is concerned.
Accused number 6.
Court pleases Your Worship. The personal circumstances of the accused are already before this honorable court in his affidavit for bail. I will not regurgitate everything, but safe to simply state that he's married. He has got 6 children. 4 of which are still minors because they are still below the age of 16 and going down. The seriousness of the case can never be overstated. However, it's clear that he's charged because he's part of a BEC, a Bid Evaluation Committee. I've not heard of any strong allegation against him, but nevertheless, bail is not opposed. But we submit that as one of my colleagues has already quoted a case of State versus Hutchison, that should never be used as some form of anticipatory punishment. Similarly, my lord, the amount set, we submit the legal principles are already set, that bail, the amount to be bailed for fixed for bail should never be tantamount to a refusal for bail. Under the circumstances of the accused person in court, yes, indeed, he's a police brigadier. However, he has indicated that his financials are in dire, more so because even some of those 2 of his children who are now majors still from time to time ask for assistance financially from him. And he, in his bail affidavit, has indicated that he can afford an amount of 1,000 rands. But nevertheless, his union, which is also responsible for the payment of his legal fees, Pinsapo, has committed to try and see if they can meet him halfway to an amount of 10,000 rands. There's a huge gap, 10,000 rands, Worship. There's a huge gap between 10 and 40, and we submit that 40 may be somewhat steep, but that 10 should be fair and reasonable under circumstances, because clearly the state conceding to bail, it's a clear indication that he's not a flight risk, and therefore he meets that purpose that is for the granting of bail. Thank you, Worship. I do not intend to flood this record with a lot of submissions.
Advocate Loubser.
Your Worship, as indicated in my earlier address, my instruction is not to take issue with the bail amount. We exceed to the amount of 40,000 rand. That is according to this.
Advocate Bishop.
May I please report, Your Worship? The accused number 11, Your Worship, a personal or particulars are recorded on an affidavit, and perusal of the affidavit will show, Your Worship, exceptionally strong emotional and personal ties in South Africa. A higher amount of bail is not going to make any difference in terms of an incentive to stay or not flee. So she's also a single mother, Your Worship, fairly recently divorced, and in the premises, Your Worship, 10 to 15,000 would be a sufficient amount of bail to act as an incentive as the state terms it, Your Worship. May it please the court.
Mr. Advocate Nijaba.
Good afternoon once more, Your Worship. Your Worship, I would have thought that even a J175 would have been sufficient to actually secure all these accused to court. It took only one simple phone call to call my client, accused number 12, when she was in Free State, and same time she drove to Silverton police station. That is an indication that there is no likelihood that accused will not stand the trial. In the circumstances, Your Worship, I know that 2,000 rand, I don't want to engage the court in a tit-for-tat auction style tactics, Your Worship, but I know that 2,000 rand may seem to be too small, Your Worship, and I think 10,000 rand will be very much relevant and suitable as police court, Your Worship. I've got nothing further to add.
Advocate Mwalu.
Thank you, Your Worship. Your Worship, all this time I thought that Christmas only comes in December until today, where I realized that Christmas can come even in March. My colleague, when they read the affidavit, they did not mention the suggested amount for accused number 13, and I was so glad. But when I found out from them that whether it was a fake Christmas present or it was an omission, then they quickly amended to say it's 40,000. Your Worship, we like to put the following before the court. The charge against the accused person is one of serious nature. However, the case of the state, it's so weak against the accused number 13, because I listened carefully when the affidavit by the investigating officer was read. Your Worship, we like to put on record that accused number 13, she doesn't have any property or business outside South Africa, and as such, even her traveling documents, they've already expired. So there is nothing that suggests that she can evade the trial because she only knows South Africa, she only knows to live in South Africa, and that's where her roots are. She's got 2 kids that are financially relying on her. The husband is unemployed. She's got a salary of a net for it's 45,000 rand, which her household expenses combined, it amounts to 44,000 rand, which if we were to invoke NCA, National Credit Act, we would say she's over indebted. Now, if Your Worship, we were to go by the suggestion of 40,000 rand, it means we are saying go do any means, including committing crime, to get money for you to pay bail. We are submitting before Your Worship that an amount of 10,000 rand will be able to be raised by her together with some extended families. I know that the question would be, we have to look at what she earns and the amount involved for the offense alleged against her. Yes, we are not saying this is a petty
charge against her. No, we are looking at what is it that she can afford now. Yes, she's earning a net of 45,000 rand, but the question is, what can she afford? And without me repeating myself like a broken CD, we are suggesting and humbly requesting the court not to indirectly deny her bail by fixing an amount that she won't be able to raise. And she will be in a position to be able to raise an amount of 10,000 rand, and as such, we request the court to fix a bail amount of 10,000 rand, which will be coupled with all the bail conditions that were read through the affidavit of the investigating officer. As the court, please.
Mr. Lepondu, Advocate Lepondu.
As it pleases the court, Your Worship, I stand by the authorities referred to earlier by my colleagues. Your Worship, the accused family, emotional, community, and occupational ties are within this area of jurisdiction of the court. I've taken instruction, I received instruction from the instructing attorney. He informs me that the husband has 10,000 rand bail available. I owe it to address the court and acknowledge, Your Worship, that whilst acknowledging the seriousness and prevalency of the crime of fraud in general, the peculiarity of this fraud is that the criminal act is found in her failure to conduct due diligence, as it appears from the address by the prosecution and from the charge sheet that has been handed. And that the common purpose, or the furtherance of a common purpose, is found, I respectfully submit, in the fact that the committee was lawfully appointed and allegedly committed the fraud in the normal course of doing their work. It's a peculiarity to this fraud. I need, however, to also point out to the Honorable Court that the allegations have been in the public domain for quite a while, having allegedly been committed in 2024. She traveled outside of the borders of South Africa and happily returned to face this charge. Except for the fraud charge, allegedly committed in the circumstances as stated above and as per the submission by the prosecution, there are no further allegations against her, e.g. of corruption or living from the proceeds of crime. I do, Your Worship, acknowledge again, for fear of repeating myself, that if you look at the amount, it's a huge amount. And we do want to thank the prosecution team, because under normal circumstances, as it has become practice in this country, you see the police and the prosecution, running to 7 days postponement, which is not what they did. And I also applauded them earlier to say they could easily have said, your client has 48 hours within which to appear before court. But we have moved swiftly to bring before court within 24 hours, which we appreciate. But again, I'm not belittling this, and I'm saying it could be. If we look at how all of us were secured in one day, that even if we were warned for court earlier, all of us would have pitched. Even if we were given summonses J175, all of us will have appeared in court, except, of course, for the ones that are in custody already on other charges. I do wish to say, Your Worship, it will be fruitless, I humbly submit, to make a return to prison when the husband is here and says, I've got the 10,000, I can immediately get it paid, and I'll comply with any other conditions that there has been suggested by the prosecution, as it pleases the court, Your Worship.
Mr. Hospen.
As it pleases Your Worship. Your Worship, as indicated in my bail application also, the accused in this matter, in this instance, is a pensioner. He retired already in May 2024 with a monthly income of 50,000 rand a month, Yusuf. So, and he's got an heart condition with children still at university. So, although I said to my learned colleague that in the amount of 40,000, that if at the means of accused, he can only afford 10 to 20,000 at the maximum, Your Worship. If we agree to the 40,000, it means that there will be no living money of expenses that he will be in even if his medical condition in that regard. So that's why I suggest an amount of 10,000 rand that will be suitable for the accused in this matter, Your Worship. He was never aware of this charge until yesterday when they were arrested. Also, he's got property in Pretoria and no passport. He will never run away. He will always pitch when the next appearance is, Your Worship, as it pleases. Thank you.
Mr. Maluleke. Maluleke for accused 16.
Yes, Your Worship. Thank you, Your Worship. In respect of the quantum, Your Worship, it is my instructions, Your Worship, that the amount of 40,000, Your Worship, it's not within reach. 40,000, Your Worship.
I can't hear.
40,000 rand.
40,000.
It's not within reach, Your Worship. Your Worship, as such, Your Worship, it is my instruction that the accused, Your Worship, will be able to make payment of 5,000 rand for bail, Your Worship, as the culprit, Your Worship.
With regards to bail conditions, any of the defense object to that? No.
No issue.
With respect to accused number 6, he has indicated that he is in possession of a passport. His wife originates from Zimbabwe, and in cases of an emergency, he might need to use his passport. My learned colleague for the prosecution has indicated that that condition or any of the conditions should only be altered with an application to court. We are requesting a flexibility in that, perhaps because we agree that the passport can be handed over to the investigating officer, that if there's an emergency, he be allowed to simply go to the investigating officer and such an arrangement be made. Only approach court if there's a refusal. We do not find that same can be a difficulty because it has happened in other courts, in other matters. I do not know if there's an objection from my learned colleague. That is the only condition. Thank you.
Yes, Advocate Manila.
Thank you, Your Worship. Worship, my learned friends have all conceded that this matter is serious. However, Your Worship, it appears, and I say this with respect, that my learned friends have merely paid lip service to the seriousness of this offence. The amount involved in this matter is 228 million. The tender was awarded due to accused number 1 using his influences within the South African police force. He had befriended accused number 3 in this matter and had a relationship with accused number 3. And accused number 3 assisted him in the compilation, together with accused number 2, of this tender document. Your Worship, that alone sparks of the degree of influence accused number 1 had with members of the South African police force, specifically accused number 3. Your Worship, This is a Schedule 5 offence. It has not been disputed. It required the arrest of all the accused. And the state has used the least invasive approach in terms of making contact with them, taking them home, affording them the opportunity to take their clothing, etc. So the state didn't adopt any robust approaches in this matter and brought this matter to court within 24 hours of the accused having been arrested, which just demonstrates the bona fides that the state has adopted in bringing the accused before court. Your Worship, my learned friend for accused number 3 and 7 alluded to the fact that this matter has been brought before the public by way of the Matlala Commission and the Parliamentary Committee Against Corruption. So, Your Worship, this matter of Medicare 24 having been awarded this tender in this large amount, the public has been made aware of this. And there is a huge outcry from the public that members of the South African police force who are meant to be their protectors are involved in such criminality. Your Worship, corruption is the scourge of society. It has literally been destroying the country piece by piece. And when we hear of such offences, the public is outraged. How much more? This offence, the nature of this offence and the gravity is shocking to the public. And I ask Your Worship not to lose sight of that. Your Worship, my learned friends have all submitted amounts that they can afford, 5,000, 10,000. Your Worship, I submit with respect that this should not be a horse trading exercise. We have to look at the offences seriously. We have to consider the public's perception and outcry seriously. And the amount that the state is suggesting, and the state has differentiated the amounts in terms of accused number 2, 3, 4, and 7 because of the nature of offences that they are being charged with versus the other accused who were members of the bid evaluation committee. So, to deal with accused number 2 and why the state is in agreement with the submission made by the investigating officer that an amount of 80,000 be imposed for bail. Your Worship, the amount I submit is not unreasonable. Accused number 2 was a director of Medicare Holdings, and that was the company that was used by accused number 1 to portray and that it had all the capabilities. Accused number 2 was aware of the false information that was being supplied by Medicare Swane in its bid document. So accused number 2, I can state, Your Worship, is one of the main instigators in this matter, in assisting accused number 1 submitting this bid with false information. I submit that he be differentiated from the other accused. The amount recommended, Your Worship, of 80,000 mitigates the risks of the accused absconding and securing his presence in court. The amount suggested is the proverbial, so to speak, sword over the heads to ensure their presence in court and their attendance in court. Your Worship, with regards to accused number 3, likewise the state has submitted and agrees with the investigating officer's submission of 80,000 being the bail amount. Accused number 3 is a member of the South African Police Force, a position that's supposed to be held with honor, and a position that of trustworthiness. That has been obliterated. And the public has seen this because much of this has been ventilated already. Your Worship, accused number 3 had a relationship with accused number 1, and it started off with a previous tender that is still being investigated. And then we go into this tender. Accused number 3 was a facilitator on the bid evaluation committee, whereas there was a conflict of interest. But nonetheless, he was in this position and ensured through the influences that this tender be awarded to accused number 1. This was all done for greed. I therefore submit to Your Worship that accused number 3 is also one of the main instigators in this matter. And therefore, the amount is differentiated from the BEC members. Accused number 4, Your Worship, it has also been submitted that bail be imposed in the amount of 80,000. Accused number 4 is a colonel in the South African Police Force, a highly respected position. Your Worship, accused number 4 has, in terms of all of the accused, has got the most number of counts and charges against her. She's got 9 counts against her, versus the BEC members who have 4 counts against them, who have one count of fraud against them. The 9 counts against accused number 4 is the corruption charges, and the corruption charges relates to 3 amounts of 100,000 rands on separate occasion being transferred through a scheme, a series of concealment and disguisement until it reached her hands. Then she had money laundering charges against her.
Right, there you have it, those live visuals coming from the Pretoria Magistrates Court. 16 accused making their first appearance in court, including various police officers in different ranks, colonels, captains, generals and brigadiers, among them over the multi-million rand Medicare 24 SAPS contract.